Local taxation, kinds of local taxes that a province and a municipality may impose. Province, taxes on the transfer of property, business taxes for those engaged in printing, publishing, 50% of 1%, business tax on those enjoying a franchise, 50% of 1%. Those engaged in the extraction of sand, gravel, quarries, 10%. Professional tax, 300. Amusement tax on concerts, theaters, circus, etc., 30%. Annual fixed fee on trucks, 500. Municipalities, business tax on manufacturer, distiller, processor, etc., of distilled spirits, liquors, etc. Business tax on wholesalers and dealers of the same. Business tax on retailers. Tax on those that export or manufacture or process essential commodities. Tax on contractors as defined in LGC. Tax on banks, non-banks, performing financing or banking functions. Tax on peddlers. Others subject to personage or VAT, excise, provided it shall not exceed 2%. Q. Pursuant to the implementation of RA 7160, the Sangguniang Panglungsod of Davao City enacted an ordinance imposing a graduated business tax where retailers would have to pay 1.25% of the gross sales or receipts exceeding 400,000 compared to the old tax ordinance where retailers only paid 1/2 of 1% of the gross sales or receipts. Mindanao Shopping Destination Corporation and other local retailers in the city contested the said ordinance for being unconstitutional and contrary to the provisions of the LGC. They further lamented that the assailed ordinance increased the tax rate on them, as retailers, by more than the maximum allowable rate of 0.15% from 50% of 1% or 0.05 of the gross receipts of 1.5%, now 1.25% of the gross receipts, thus violating Section 191 in relation to Section 143 and 151 of the Code. Is the ordinance valid? Yes, the ordinance is valid. It must be pointed out that the limitation under Section 191 of the LGC was provided to guard against possible abuse of the LGU's power to tax. In this case, however, strictly speaking, the new tax rate for petitioners as retailers under the assailed ordinance is not a case where there was an imposition of new tax rate. Rather, there is merely a rectification of an erroneous classification of taxpayers and tax rates, like of grouping retailers and wholesalers in one category and their corresponding rates. The amendment of the old tax ordinance was not intended to abuse the LGU's taxing powers, but merely sought to impose the rates as provided under the LGC, as in fact, the tax rate imposed was even lower than the rate authorized by the LGC. In effect, the assailed ordinance merely corrected an old ordinance so that it will be in accord with the LGC. Mindanao Shopping Destination Corporation versus Duterte, June 6, 2017. Q. After the Comprehensive Agrarian Reform Law was passed, NDC lands were transferred to Comprehensive Agrarian Reform Law beneficiaries who formed themselves as the merged NDC Guthrie Plantation Incorporated, NDC Guthrie Estates Cooperatives Filipinas, a private organization engaged in palm oil plantation, entered into a lease contract agreement with NGPI and GEI. The Provincial Assessor of Agusan del Sur Provincial Assessor is a government agency in charge with the assessment of lands under the public domain. It assesses Filipinas properties found within the plantation area, which Filipinas assailed before the Local Board of Assessment, Appeals, LBAA. In its decision, LBAA found the assessment of the provincial assessor unreasonable and rules that the market valuation should be based on the laws of Department of Agrarian Reform, since the area is owned by the NTC, a quasi-governmental body of the Philippines. Filipinas appealed before the CBAA, which ruled that A. Filipinas should not be made to pay for the RPT on the lands owned by the multi-purpose cooperative, as well as on the roads, and B. The road equipment and haulers are not real properties, hence not subject to RPT. Is CBA correct? Yes. NGPI-NGEI, as the owner of the land being leased by Filipinas, falls within the purview of the law. Section 234 of the Local Government Code exempts all real property owned by cooperatives without distinction. Nothing in the law suggests that the real property tax exemption only applies when the property is used by the cooperative itself. Similarly, the instance that the real property is leased to either an individual or corporation is not a ground for withdrawal of tax exemption. Despite the land being leased by Filipinas when the roads were constructed, the ownership of the improvements still belongs to NGPI-NGEI, as provided under Article 440 and 445 of the Civil Code. The land is owned by the cooperatives at the time respondent built the roads. Hence, whatever is incorporated in the land, either naturally or artificially, belongs to the NGPI-NGEI as the landowner. Although the roads were primarily built for Filipinas' benefit, the roads were also being used by the members of NGPI and the public. Furthermore, the roads inured to the benefit of NGPI-NGEI as owners of the land, not only by right of accession, but through the express provision in the lease agreement. Letter B. No, the road equipment and mini haulers shall be considered as real property, subject to real property tax. The provincial assessor is correct in claiming that the phrase pertaining to physical facilities for production is comprehensive enough to include the road equipment and mini haulers as actually, directly, and exclusively used by respondent to meet the needs of its operations in palm oil production. Moreover, mini haulers are farm tractors pulling attached trailers used in the hauling of seedlings during a planting season and in transferring fresh palm fruits from the farm or field to the processing plant within the plantation area. The indispensability of the road equipment and mini haulers in transportation makes it actually, directly, and exclusively used in the operation of respondent's business. Provincial Assessor of Agusan del Sur versus Filipinas Palm Oil Plantation, October 5, 2016. National Power Corporation alleges that payment under protest under Section 252 of the LGC is required when the reasonableness of the amount assessed is being questioned, challenging the very authority and power of the assessor to impose the assessment and of the treasurer to collect the tax is an attack on the very validity on any increase and not merely on the amounts of increase in tax. Thus, such payment is not a condition sine qua non for the LBAA to entertain the NPC's challenge on the validity of the tax imposed on its tax-exempt properties. Is NPC correct? No. As settled in jurisprudence, a claim for exemption from the payment of real property taxes does not actually question the assessor's authority to assess and collect such taxes, but pertains to the reasonableness or correctness of the assessment by the local assessor, a question of fact which should be resolved at the very first instance by the LBAA. NPC's failure to comply with the mandatory requirement of payment under protest in accordance with Section 252 of the LGC was fatal to its appeal, We note that it is not the first occasion where this court ruled that the NPC, in claiming tax exemption, questions the reasonableness or correctness of the assessment by the local assessor and not the legality of the assessment for his authority to assess real property tax. As such, petitioner should have first complied with Section 252. Its failure to prove that this requirement has been complied with renders its administrative protest under Section 226 of the LGC without any effect. No protest shall be entertained unless the taxpayer first pays the tax. National Power Corporation versus the Provincial Treasurer of Benguet, November 14, 2016. Is the National Grid Corporation of the Philippines, NGCP, exempt from real property taxes? Yes. Section 9 of RA 9511 states that NGCP's payment of franchise tax is in lieu of payment of income tax and any and all taxes, duties, fees, and charges of any kind, nature or description, levied, established, or collected by any authority whatsoever, local or national, on its franchise, rights, privileges, receipts, revenues, and profits, and on properties used in connection with its franchise. Section 9 of RA 9511 clearly stated that the NGCP's in lieu of all taxes clause includes taxes imposed by the local government on properties used in connection with NGCP's franchise. However, NGCP's tax-exempt status on real property due to the in lieu of all taxes clause is qualified. NGCP shall be liable to pay the same tax as other corporations on real estate, buildings, and personal property exclusive of their franchise. National Grid Corporation of the Philippines versus Oliva, August 10, 2016. The City of Manila assessed Cosmos local business taxes and regulatory. Cosmos protested the assessment through a letter arguing that tax ordinances have been declared null and void and argued that the collection of local business tax under two provisions of the same ordinance constitutes double taxation. Cosmos received a letter from the city treasurer denying their protest, thus constrained to pay the assessment, and filed its complaint with the RTC, praying for the refund or issuance of a tax credit certificate. The RTC, in its decision, ruled in favor of Cosmos, but denied the claim for refund. Cosmos' motion for partial reconsideration was also denied, hence the petition for review before the CTA. CTA ruled in favor of Cosmos. Petitioner, instead of filing a motion for reconsideration or new trial, the petitioners directly filed with the CDA and bank a petition for review. Whether the CDA and bank correctly dismissed the petition for review. Yes, the filing of a motion for reconsideration or new trial before the CDA division is an indispensable requirement for filing an appeal before the CDA and bank. The CDA and bank was correct in interpreting Section 18 of RA 1125 as requiring a prior motion for reconsideration or new trial before the same division of the CDA that rendered the assailed decision before filing a petition for review with the CDA in bank. Failure to file such motion for reconsideration or new trial is cause for dismissal of the appeal before the CDA in bank. City of Manila versus Cosmos Bottling Corporation, June 27, 2018. On June 17, 2004, the Philippine Ports Authority PPA received a letter from the City Assessor of Davao for the assessment and collection of real property taxes against its administered properties. It appealed the assessment by a registered mail to the local Board of Assessment Appeals. While the case was pending, the City of Davao posted a notice of sale of delinquent real properties, including the 3 properties of PPA. The local Board of Assessment Appeals dismissed the PPA's appeal for having been filed out of time. PPA appealed before the Central Board of Assessment Appeals, but this appeal was denied in the Central Board of Assessment Appeals. Thus, it filed an appeal with the Court of Tax Appeals. The PPA claimed that it did not receive any warrant of levy for the 3 properties which were sold to respondent City of Davao, or any notice that they were going to be auctioned. It was informed that it had 1 year to redeem the property. Thus, it filed a petition for certiorari and injunction with the Court of Appeals. The CA had jurisdiction. No. In real property tax cases such as this, the remedy of a taxpayer depends on the stage in which the local government unit is enforcing its authority to impose real property taxes. Moreover, law confers jurisdiction. PPA has failed to cite any laws supporting its contention that the Court of Appeals has jurisdiction over this case. On the other hand, Section 7, Paragraph A, Number 5 of Republic Act 1125 as amended by Republic Act 9282 provides that the Court of Tax Appeals has exclusive appellate jurisdiction over decisions of the Central Board of Assessment Appeals in the exercise of its appellate jurisdiction over cases involving the assessment and taxation of real property originally decided by the Provincial or City Board of Assessment Appeals. Philippine Ports Authority, PPA versus City of Davao, June 6, 2018. On 26 December 1992, the Sangguniang Bayan of the Municipality of Pasig enacted Ordinance Number 25, which under its Article 3, Section 32, imposed a franchise tax on all business venture operations carried out through a franchise within the municipality by virtue of Republic Act 7829, which took effect on 25 of January 1995. The municipality of Pasig was converted into a highly urbanized city to be known as the City of Pasig. On 24 August 2001, the Treasurer's Office of the City Government of Pasig informed the Manila Electric Company, Meralco, a grantee of a legislative franchise, that it is liable to pay taxes for the period 1996 to 1999, whether the City of Pasig had valid basis for its imposition of franchise tax for the period 1996 to 1999. No. Under the Local Government Code, LGC, of 1991, unlike a city, a municipality is bereft of authority to levy franchise tax. Thus, the ordinance enacted for that purpose is void. The conversion of the municipality into a city does not lend validity to a void ordinance. Neither does it authorize the collection of the tax under said ordinance. The power to impose franchise tax belongs to the province by virtue of Section 137 of the LGC, City of Pasig versus Manila Electric Company, March 7, 2018. Can a golf course be considered a place of amusement and therefore be within the power of LGU to impose amusement tax? No. Section 42 of the revised Omnibus Tax Ordinance as amended, imposing amusement tax on golf courses is null and void, as it is beyond the authority of respondent Cebu City to enact under the LGC. A golf course cannot be considered a place of amusement. People do not enter a golf course to see or view a show or performance. Proprietor or operators of the golf course do not actively display or stage or present a show or performance. People go to a golf course to engage themselves in a physical sport activity. An LGU may exercise its residual power to tax when there is neither a grant nor a prohibition by its statute, or when such taxes, fees, or charges are not otherwise specifically enumerated in the LGC, NIRC, or other applicable laws. In the present case, Section 140 in relation to Section 131 letter C of the LGC already explicitly and clearly cover amusement tax in Cebu City must exercise its authority to impose amusement tax within the limitation and guidelines as it set forth in said statutory provision. Alta Vista Golf and Country Club versus the City of Cebu, January 20, 2016. Capital Wireless is in the business of providing international telecommunication services. Capwire has signed agreements with other local and foreign telecommunications companies covering an international network of submarine cable systems. The local government of Batangas considered the submarine cable systems as real property subject to real property tax. Is the local government of Batangas correct? Yes. Submarine or undersea communications cables are akin to electric transmission lines, which are no longer exempted from real property tax and may qualify as machinery, subject to real property tax under the LGC. Both electrical lines and communications cables, in the strictest sense, are not directly adhered to the soil but pass through posts, relays, or landing stations, but both may be classified under the term machinery as real property under Article 415, Number 5 of the Civil Code, because such pieces of equipment serve the owner's business or tend to meet the needs of his industry or works that are on real estate. Moreover, a portion of the submarine cable falls within what the unique clause would define as the country's territorial sea to the extent of 12 nautical miles outward from the nearest baseline over which the country has sovereignty. Further, under Article 79 of the UN clause, the Philippines clearly has jurisdiction with respect to cables laid in its territory that are utilized in support of other installations and structures under its jurisdiction. And as far as LGUs are concerned, the areas described above are to be considered subsumed under the term municipal waters, which under the LGC includes not only streams, lakes, and tidal waters within the municipality, but also marine waters included between two lines drawn perpendicularly to the general coastline, from points where the boundary lines of the municipality or city touch the sea at low tide, and a third line parallel with the general coastline and 15 kilometers from it. Capital Wireless versus Provincial Treasurer of Batangas. Filipinas Palm Oil Plantation is a private organization engaged in palm oil plantation. It leases the land from NGEI Cooperative. The LBAA assessed Filipinas of real property taxes on the land it leases, on the road it built primarily for the benefit of the plantation, and on the machineries that are not attached to the land. Is the assessment of LBAA proper? No. Under Section 133, letter N of the LGC, the taxing power of LGUs shall not extend to the levy of taxes, fees, or charges on duly registered cooperatives under the Cooperative Code. NGEI, as the owner of the land being leased by respondent, falls within the purview of the law. Section 234 of the LGC exempts all real property owned by cooperatives without distinction. Nothing in the law suggests that the real property tax exemption only applies when the property is used by the cooperative itself. Similarly, the instance that the real property is leased to either an individual or corporation is not a ground for withdrawal of tax exemption. The roads that Filipinas Palm constructed within the leased area should not be assessed with real property taxes. The roads constructed became permanent improvement on the land owned by the NGEI by right of accession under Article 440 and 445 of the Civil Code. Hence, whatever is incorporated in the land, either naturally or artificially, belongs to the NGEI as the landowner. Although the roads were primarily built for Filipinas Palm benefits, the roads were also being used by the members of NGEI and the public. However, The assessment pertaining to the machinery is proper. The definition of machinery under Section 199 of the LGC includes machineries which may or may not be attached permanently or temporarily to the real property. Can administrative remedies be dispensed with in disputes involving real properties? Yes. In disputes involving real property taxation, the general rule is to require the taxpayer to first avail of administrative remedies and pay the tax under protest before allowing any resort to a judicial action, except when the assessment itself is alleged to be illegal or is made without legal authority. For example, prior resort to administrative action is required when among the issues raised is an allegedly erroneous assessment, like when the reasonableness of the amount is challenged, while direct court action is permitted when only the legality, power, validity, or authority of the assessment itself is in question. Stated differently, the general rule of a prerequisite recourse to administrative remedies applies when questions of fact are raised. But the exception of direct court action is allowed when purely questions of law are involved. Capital Wireless versus Provincial Treasurer of Batangas, May 30, 2016.